Good morning, everybody, and welcome to another of our webinars in our enterprise series. This morning, we're going to be talking about attracting talent to the UK, navigating immigration, employment law, and tax. As I always say, we have a kind of a strong following of delegates who come to these enterprise webinars. So lots of you probably do know us pretty well. But for those of you who don't, we're a top 10 audit, tax, and advisory firm. And we work with businesses across all different sectors, including not-for-profit and private client. We're also part of More Global, which is an international network with presence in over 100 countries. And we were also one of the first accountancy practices to have a legal practice. And we've also recently acquired a law firm called SGD, Staff & Guild Davies. And so we've now got a very much expanded legal offering called More SGD Law, which includes property, family law, and private client specialists as well. So, as I said, today we're going to be talking about attracting talent to the UK and all the considerations that you need to think about to ensure that you're compliant with immigration, employment and tax. So we're going to be looking at it from all those perspectives. So I'm delighted this morning to be joined by Rebecca Hone, who is Director of Immigration Legal Services from More SGD Law, Donal Moon, who is Employment Law Advisor with More SGD Law, and Louise Fryer, who is a Global Mobility Tax Lead from More Kingston Smith. So I'm going to be asking the panel some questions. Please do pose your own questions. These webinars are for you. Please do put them in the Q&A chat function. It's a lot easier for me to keep track of them there, and then I will weave them into the panel session. If we don't get a chance to answer your question as we go along, then we'll aim to get back to you on a one-to-one after the webinar has finished. The session is being recorded, so please do share it with any of your peers or colleagues who weren't able to make this morning. Yeah, so that's it really. So I think we'll kick off. So I think it would be nice just to get a little overview from the panelists of sort of generally speaking, where is the global mobility market going in the business space at the moment? So just a few thoughts from each of you before we sort of dive into some of the more detailed questions. Maybe Louise, you might want to kick off.
Yeah, sure. Global mobility, tax and social security is always an environment that is very dynamic. And whereas before, companies would send their employees away on an assignment for 2 or 3 years and give it to them as a benefit for being a high performer. We're now seeing very much more that companies are literally going and sourcing their talent overseas and bringing them back to the UK, or setting them up in the country that they're living in. So the whole dynamic in a lot of ways has changed. The talent is driving their reward packages and their circumstances rather than it being the other way around. We're seeing a lot of individuals going out to Dubai, and it might be that they've made their money, they've spotted an opportunity, they're going to go and live in Dubai and everything is tax-free. How long that will last be interesting to see. But it's just one of those things. It's a trend at the moment. What comes next, we don't know, but it is very interesting to see that global mobility now has a place at the table, that it's now part of the strategic decision-making process, which before it wasn't. It was just something that HR did.
Yeah. Donal, what about from your perspective, from a legal perspective?
Yeah, so that very much chimes in with what we're seeing. So we're still seeing a lot of requests from people coming to the UK, and particularly in the IT and engineering sectors, and that can be secondments, projects, people setting up branches, or certainly still the will to attract overseas talent to the UK. But I think, as Louise said, we're also seeing a lot of companies dipping their toe in markets overseas as well. So getting a few inquiries around that, and as you said, Louise, people working remotely overseas for UK entities seems to be quite a strong trend at the moment.
Donal and Rebecca?
I mean, following on from Donal and Louise, the UK remains an attractive place to work and live. And in terms of overseas employees coming to the UK, we haven't seen a reduction in the numbers. Labour is made it harder in some aspects with regard to sponsoring workers. But there is definitely a push to recruit from overseas in those sectors that Donal mentioned, such as IT and engineering, and those businesses that previously, prior to Brexit, didn't need a sponsor license for the UK. We've seen an influx of those types of applications coming in, but I'll go into all of that as we progress.
Well, staying with you then, Rebecca. So first question really. So if we've got an overseas employee traveling to the UK for business on a very short-term basis, so longer than 6 months, is a work visa or permit required? And what process do we go through to get that?
So if an overseas employee is coming to the UK for 6 months or less, there are certain permitted business visitor activities, such as attending meetings, negotiating and signing deals and contracts. They could be information gathering for their overseas employment, or even working remotely for their overseas employer, provided this isn't the primary purpose of their visit. There are also some permitted intra-corporate activities which overseas employees can do whilst being a visitor in the UK for up to 6 months. They could be advising and sharing skills and knowledge on internal projects with UK employees of the same group. But importantly, if they're coming to the UK as a visitor for up to 6 months, they must continue to be paid from outside the UK. If they are coming to the UK to carry out work activities not permitted under the visitor rules, then they likely will need to be sponsored if they do not hold another type of valid residence visa. It's important to note that there is a new digital immigration permission for visitors, which has come into effect already for most visa and non-visa national countries. So this does now include the USA, Canada, Australia. But from the 2nd of April, all non-British and non-Irish visitors to the UK, so this includes EU countries, will have to have what's called an ETA, an electronic travel authorization, which is similar to the ESTA in the States, and they'll have to apply for it prior to entering the UK. Normally, it does not take long to get an ETA approved, but it's important to keep this in mind if you are a global group and you're sending employees to the UK quite regularly.
So Donal, coming to you then. So if an employee is coming over for this sort of short period of time, can they remain on their overseas contract, or do we need to issue them with a new UK contract?
Yeah, so even for short-term assignments like this, I would always recommend a separate contract. It just makes things a lot clearer and certain for both parties concerned. Employers can either use, so there's a few options. Employers can either use secondment agreements or fixed-term contracts, and they can either, depending on the expert advice they receive from all angles, opt for the home entity or the UK entity to be the employer in this scenario. If it's going to be the home entity, we ordinarily advise that a lawyer from that country, the home country, should draft the contract and then have it reviewed by a UK lawyer. And that's just to ensure that the UK statutory rights are included, but at the same time striking a balance between that and not conferring too much control of the relationship on the UK entity, because that can sometimes cause confusion about who's the employer in the scenario. If it's going to be the UK entity that's the employer, a UK lawyer should obviously draft it, but in collaboration with a lawyer from the home entity so that the rights and obligations in the home country are properly dealt with under the contract. What happens to them? Do they get suspended? Do they continue, depending on employer preference? And again, expert advice that's received about matters such as tax. There's a few risks to bear in mind, though. So if you're using a secondment agreement and having the home entity as the employer, that's a really popular option we find with our clients, and probably because it can help to keep the pay lower than for UK employees. I think that might be one of the motivating factors. But employers obviously have to factor in the cost of relocation and support for UK accommodation on the other side of that. But things aren't quite as clear cut as they seem. It seems nice and easy, but there are risks. So number one, the individual will have certain workers' rights just because they're a secondee doesn't mean they don't have any rights. They still have workers' rights, and that includes protection from discrimination, protection as a whistleblower, and victimization. So worker status doesn't give you quite as many rights as being an employee, but it does include important protections, such as potentially compensation for injury to feelings and uncapped compensation for detriment, including claims potentially against individuals as well as companies. I thought it might be helpful if I gave an example of where secondments can go horribly wrong, just from experience. Now, this isn't something I've dealt with personally, but I've read about it. So it's where an employer expressed a view that a secondee didn't fit in with the team. And actually, the protected characteristic of national origin could very, very easily be described as the motivating factor behind that viewpoint. Whether that is accurate or not, that doesn't prevent someone from bringing a claim on that basis. And they wouldn't even need 2 years service to do it, because the Equality Act claims can apply right from the beginning of the recruitment process. The other big risk in secondment situations like this is that individuals can claim they're in fact employed by the UK entity, whatever you say in the contract, depending on how the relationship runs in reality. So just a few thinking points for employers: just try and reduce risk by ensuring the contract's very, very clear that it's the overseas entity that's the employer, and that duties are owed primarily to the overseas entity. Try and avoid integrating the employee too much in the UK entity, and just ensure that the day-to-day relationship is managed by the home entity rather than the UK one. Also helpful to establish a clear basis for the secondment being on a fixed term, I always find, so that it can be justifiably brought to an end. I think I also mentioned fixed term contracts, so I'll just deal with that finally, but I appreciate this is quite a long answer, but there's quite a few things to unpack with this one. If an employer opts for a UK fixed term contract in this scenario, I'd just say, remember that the non-renewal of a fixed term contract legally a dismissal in the UK. So if it turned out that someone on this relationship was dismissed and replaced with someone who was British or another national origin, for example, rather than the role simply coming to an end and not being replaced, they might try to claim that their dismissal was discriminatory.
Thanks, Donal. Yeah, long but useful. So coming to you, Louise, I guess the next thing to think about is all the tax considerations. And I guess many employers might think that so long as the correct visa is in place and the contract of employment fulfills all the necessary criteria, and that if it's less than 6 months, that there's nothing they need to do from a tax or payroll perspective. But I suspect that's not quite all of it, is it?
No, as I wouldn't have a job. The most common misconception is that an employee has got their visa, so they don't have to worry anymore. That is absolutely not the case. Tax and social security do not follow, very unhelpfully, but they don't follow the same rules as the visa does. So the visa is giving you the right to work in the UK. That's great, but then an employer and an employee have to think about what their personal situation is. If we're looking at less than 6 months, another common misconception is it's okay, it's less than 6 months, 183 days covered by the treaty. Again, unfortunately not the case. The default position in the UK is that any employee coming to work here, even if only for 1 day, must be added to UK payroll and tax and national insurance withheld. That comes as a big shock to a lot of people. There are ways that this can be mitigated. So where the home country has a tax treaty in place with the UK, they can enter into an agreement called a short-term business visitors agreement, which uses the treaty article to say, okay, so long as conditions are fulfilled, then UK tax isn't due. But you can't just make that assumption anymore. Years ago, you used to be able to. Now you can't. You have to have that agreement in place. As part of that agreement, the employer has to sign up to tracking their employees, so how long they're spending in the UK, what they're doing when they're here, who they're seeing. And then every year they submit a report to HMRC of the people that have been in the UK for work purposes. Different amounts of days in the UK attract different levels of information. So if an employee is here for less than 60 days, the employer has to have a record of it, but they don't submit anything to HMRC in terms of names. They just say everyone's fine. And then the further you go up, the more information you need. Who is it? Who are they seeing? What are they doing? Why are they here? That kind of thing. It's slightly difficult because the employer also has to track days that are personal days. So if the employee stays for a holiday, the employer has to know about it and record it on their sheet. And that tends to be the tricky bit because people feel that their privacy is being invaded. There is also an arrangement whereby employees can be exempted from UK national insurance when they come to the UK. And this is something that every visitor to the UK where there is a social security agreement in place should have. There's no time limit in terms of, oh, I'm only there for one day, you should hold this certificate. It is applied for in the home country, the individual holds it, and it means they remain in their home country social security system. They don't have to worry about the UK. Where there is no treaty or no agreement with the UK and the home country, there is something that's known as the 52-week exemption, but advice should always be sought because, again, it turns on certain criteria being met. In that scenario, you have 52 weeks, you carry on paying into your home social security, and then you go onto the UK system, and it works vice versa. One of my favourite, as I said, one of my favourite things is when people say to me, no, the 183 days, don't need to do anything, because again, that's another common misconception, but they have to think about the type of work that's being undertaken, which entity is bearing the cost, who's receiving the economic benefit. And this ties in with Donal and his employment contracts and all that kind of thing, because if you've got a UK employment contract, as soon as you set foot in the UK, you're taxable. So there is a lot, again, to think about in terms of secondees, whether it's less than 6 months or more than 6 months. This planning can be done, but you have to have agreements and things up front.
Thanks, Louise. Rebecca, what about sort of recruiting for skilled workers? So we've got a UK entity, it's looking to bring skilled workers here. How do we go about sponsoring individuals from overseas? And somebody actually, one of the specific questions was around somebody with a graduate visa that was, potentially due to expire quite soon. How do we deal with that?
Right. So if a UK business is looking to employ a candidate who's on a graduate visa, in order to do this, they will need to apply for a skilled worker sponsor license if they don't already have one. With this sponsor license, it allows them to sponsor the individual on the graduate visa in addition to any other migrant workers who require sponsorship. To be sponsored, the candidate will need to meet specific skill level and salary requirements. And in the license application, the business will have to include certain mandatory information regarding the candidate's role, or else the license could be granted without the required certificate of sponsorship. Certificate of sponsorship is what you assign to the worker in order for them to apply for their visa. If this, what we call cause, is not allocated when the license is granted, this could delay submitting the visa application as an additional cause must be applied for. And those processing times are up to 18 weeks, worst case. So with a skilled worker license application, the UK business must prove through the provision of various documents that they are a legitimate business operating and actively trading in the UK. For example, they can provide their annual accounts, their registration with HMRC as an employee for PAYE and national insurance, VAT registration, proof of a business premises, etc. They also need to establish that they have systems in place which can comply with the various sponsorship duties, including maintaining proper records and monitoring employees. For example, when they change work location, tracking their visa expiries, their attendance at work, change in their job duties. Failure to comply with these duties can result in quite drastic consequences, such as suspension or downgrading of their sponsor license. Once the license is granted, as I said, the cause can be assigned to the candidate, following which the visa application can be submitted. With a graduate visa candidate, they can apply in country, so long as their visa has not expired. Importantly, they cannot travel outside the common travel area while their application is pending. Processing times are currently around up to 2 months, but there is that option to expedite. But with a graduate visa candidate, they do have the right to work in the UK. So they can be offered the role and start working prior to being granted with their skilled worker visa, and so long as they make an in-time application. It's also important to keep in mind that when sponsoring skilled workers, they must be paid either the higher of 38,700 per year or the standard going rate for their occupation code. Graduate visa holders do have a lower salary threshold. It's called the new entrant category, and they can be paid this lower salary threshold for up to 4 years when combining their graduate leave and their skilled worker leave. With the skilled worker route, there is that option for those workers to settle in the UK after 5 years. So normally, our clients tend to sponsor initially for 2.5 years and then follow that with an extension, just so that they can see how things are going with that sponsored worker.
Brilliant, thanks, Rebecca. Somebody's asked a question. You may well have covered all the points in your previous answers, but they've got a colleague coming over from France to train and work here in the UK for 3 months. What do they need to be aware of? And also just to add that they won't be paying him. His employer in France will continue to pay him. Is there any sort of additional nuances around that we haven't sort of covered already?
So if this individual is coming for up to 3 months, it should be fine to come in as a visitor to undertake training in the UK. But it's also important to keep in mind the ETA. So if they're coming into the UK on or after the 2nd of April, they need to apply for that ETA prior to arriving. And so long as they are not being paid in the UK and they're coming here primarily just to undertake training, then there shouldn't be an issue them coming to the UK as a visitor.
Thanks, Rebecca. Donal, just coming to you on to the previous question about sort of getting someone over on a sponsorship. Are there any sort of issues around withdrawing a sponsorship offer, and what options would the employer have from an employment law perspective?
Yeah, so we often see this in situations where visa processes are delayed or rejected and an offer has been made. It can certainly cause complications. The employer could, of course, choose to pull the plug and hope for the best, but it's not something we'd recommend. There's a number of risks to doing that. So I think the first thing to consider is that if the visa process delayed or rejected, then the candidate could end up claiming compensation for 3 things. So firstly, the delay period, if the offer was unconditional, so you've given them a definite start date. 2, potentially even the notice they would have received if the contract were terminated under normal circumstances. And 3, possibly even if they were headhunted into the role, compensation for breach of contract. So in other words, they were induced to leave a previous role for this one, so compensation for that potentially. I've seen that done in many tribunal cases. The other thing to bear in mind is that some employers think this is kind of low risk or risk free. It's wording I kind of often hear bandied about because the person's got less than 2 years service, but actually they're still protected against rejection or dismissal for discriminatory reasons. And again, going back to the previous answer, that includes discrimination based on national origin, which is a key factor in these cross-border cases often. So of course the employer may be able to argue against it. They probably will based on the immigration issues, but defending a claim in itself involves significant time and costs, and tribunal decisions, I think it's fair to say, are very, very fact sensitive in this area. What we'd normally advise clients to do is to follow a sufficiently fair and well evidenced process. So while you don't necessarily have to have a fair reason for dismissal in legal terms, acting reasonably and being able to objectively justify your decision and showing that all other options have been considered and found not to be viable before you arrive at that nuclear option of withdrawing the offer would hopefully help you rebut any allegation that the decision to withdraw was discriminatory. So in a case, for example, think about a case where someone does have 2 years service. What would you do with if a right to work issue arose? You would probably base the approach on treating it as some other substantial reason dismissal, and looking at all the options before arriving at that point. So I think following that, mirroring that type of process in this sort of case would be helpful. There are some other options an employer could and probably should consider before they get to the point of withdrawing the offer. So they could offer a fixed term contract that's conditional on the visa status. And that would provide some flexibility to review the contract once the visa is resolved. But just again, I think be aware, as I said, I think I hinted earlier, the fixed term contracts aren't magic bullets. They're not a magic cure-all. They do come with risks, especially if you have to terminate at some point. If you're going to offer, you could offer a permanent role, but if you're going to do that, I'd just say include clear terms in the contract, stating the employment's conditional upon obtaining the valid work visa or sponsorship license, and doing that helps manage risks associated with visa delays or rejections. But certainly, I think the key point is with contracts, you hope never to get to this point in the first place where it's necessary to think about withdrawing an offer which turns out to be unconditional. So certainly draft conditional clauses that account for visa delays and include flexibility around the start date. And just communicate with the candidate. We often find conversation is the best cure in these cases where there's uncertainty. Communicate with them about their employment status whilst awaiting the approval, and let them know what's possible and what the potential risks are. And as always, and I suppose this is teaching people to suck eggs in a way, but proper documentation and management practice are crucial to maintaining compliance and reducing potential legal risks. I think a clear paper trail is always helpful if there's a dispute.
Thanks, Donal. Louise, is there anything that the company needs to consider from an employee perspective here?
Not that is specific. I mean, ultimately, you've got the graduate, you've offered them a job, they need to go on UK payroll, pay tax and national insurance. So from an employer perspective, there isn't. They're treated just as a normal UK employee would be. But what I would say, certainly around the trends we're seeing at the moment, is talk to that person about whether they're likely to want to, go back to their home country and work from there at times. Maybe not for 6 months or a year, but they might decide they want to go home, have a holiday, and then work and extend that time for work. So I would always make sure that some kind of chat is had around that and whether or not it's permitted, what the company policy is around that kind of thing. But in terms of actually anything special that needs to be done from a tax and national insurance perspective, there isn't anything apart from adding it to payroll.
Rebecca, what about if we've got a situation where we've got a business that's headquartered in the EU, they're looking to establish a UK branch, which will require sending sort of senior staff to the UK to set up and manage that operation. Can they apply for a sponsor license to transfer these overseas employees to the UK?
With this scenario, there's a few options. So if this EU business already has an actively trading and operating UK branch or subsidiary, which importantly must be linked either by common control, ownership or control, or a joint venture agreement to the European entity, then the UK entity can apply for what's called a global business mobility senior specialist worker license. Very long-winded, but it used to be called the intra-company license. And this is for those overseas employees moving to the UK on fixed term assignments. With this type of sponsorship, the salary is a bit higher. It's at 48,500. Again, they have to be paid this minimum or the going rate for their occupation code. There are additional requirements with regard to length of service. So the overseas employee must be with that EU entity for at least 12 months, unless they're going to be paid at least 73,900 in the UK per year. Unlike the skilled worker route, there's no English language requirement, so that could prevent any delays with the visa application process. But then if we look at the other option for those EU companies that do not yet have an actively trading UK entity, what they will need to do is apply for the UK expansion worker license, which allows for up to 5 senior individuals from the EU entity to come and set up the UK business. This is a much more difficult application. It's very document heavy in comparison to the other types of license applications. They must show what's called a UK footprint. So what that means, they need to be registered with Companies House as either an overseas company branch or a wholly owned subsidiary, or they need to evidence a UK business premises, which can be evidenced with a lease agreement or proof of purchase. They also need to show that they have at least 3 years trading overseas, and they must provide a substantial and credible UK expansion plan, which shows that they will establish a UK trading presence within 2 years. There's also another type of license for those being seconded to the UK. So if an employee from the EU business is coming to do work for a different UK organization separate to the one linked to the EU entity, the EU business must have a high value, at least 50 million contract with a UK organization, and that UK organization needs to apply for the secondment worker license. So there's a lot to consider in terms of options if overseas businesses, including EU businesses, are setting up in the UK. And it's important to select the right option as each type of license application has different processing times. And for example, the UK expansion worker is ineligible for to be expedited. So it can take some time with that type of license.
Thanks, Rebecca. Donal, are you able to go into a little more detail about the employer's options from an employment law perspective?
Yeah, so it sounds to me here that the employer is looking for a little longer term arrangement for senior employees to come to the UK and set up the UK branch. So that being the case, there's several options that the first that springs to mind is secondment agreements. So yeah, those can certainly be used. If I was talking purely from an employment law perspective, these are probably better for shorter term assignments, such as the one in the first question we had today. But actually companies can and do use them in these scenarios because there can be tax advantages to leaving the employee on their home contract and having a letter of assignment as long as certain conditions are met. But if that's not a concern, if those tax issues are not a concern, and the UK entity, they want the UK entity to be the employer, there's a few options available there. So either permanent contracts, and it could be argued, again, if you're looking at very senior staff, permanent contracts can provide stability and security and reflect the person's seniority with no specified end date. That could be something that fitted. Or the other alternative would be fixed term contracts. So if we know that the project's got a fixed term duration, we know it will be finished at a certain point, could use fixed term contracts. The advantage of that in this scenario, of course, is they automatically end on the agreed date unless they're renewed. So yeah, I'd say sometimes they're viewed as good in these good options in these scenarios, but again, they're not a get out of jail free card because there are still dismissal and unfair dismissal and discrimination risks, and those will probably heighten because I know that the government's looking at making unfair dismissal a day one right from 2026. So the risks highlighted with these types of contracts will increase at the same time as that new law comes in. I suppose just looking at some thinking points for employers thinking of doing this. So I'd just say, I think this probably goes without saying, but just make sure that the contract covers all of the key areas of the employment relationship, whichever contract you choose. And key points that can tend to be missed in these scenarios is all the benefits, relocation costs, and particularly what happens when the assignment ends and the individual needs to be recalled to their home country or sent to another country. Those things can tend to be missed or missed out of the contracts, and it's just very important that they're drafted carefully to cover those scenarios.
Thanks, Donal. Louise, what about differences in the sort of the UK tax and social security position of an employee that might be working for a UK branch as opposed to a UK subsidiary of an overseas company or even of a UK company? Is there anything that the company can do from a tax planning perspective here?
Yeah, I mean, where we're looking at a longer term secondment or a longer term period working in the UK, ultimately, whether it's a branch or a subsidiary, it's still a UK permanent establishment. So the obligations for the employer are very much the same, regardless of what type of entity it is. What I think is important is that where you've got senior staff coming to the UK to set up, manage operations, get things running, there is tax relief available if certain structures are put in place. And this links very closely with Donal's, contract talk, and we do work very closely together when it comes to this because there are pros and cons on both sides. We often see employees are offered assignment-related payments and allowances to help them settle in. All those payments should go through payroll as taxable in the usual way, but tax relief may be available on travel and subsistence costs, including housing costs if the assignment is for less than 2 years. The tax relief is claimed by the individual where they file their UK self-assessment return. However, there are a number of criteria that must be satisfied. The individual must remain on their home country contract and have a letter of assignment covering their period in the UK. The letter of assignment must clearly state the length of the assignment, and this is where we have the 2-year limit, because if there is no specified time in that letter of assignment, then HMRC will not allow the tax relief claim. Housing costs must be reasonable and appropriate. HMRC often check the type of accommodation an assignee is living in, and deductions on the amount of tax relief available may be made if an individual comes to the UK with his family or lives in a larger property or a more expensive area than HMRC deem necessary. We see a lot of Americans coming over and they will live in an area of expensive property, but the reason they give is that is where the American children's schools are, that is where their community is. Sometimes HMRC will accept that, sometimes they won't. But either way, there is usually at least an amount to be claimed, even if it's not the full amount of housing. What is quite interesting is that housing does not have to be paid by the employer. So it can be that the employee is paying for his own housing out of his net income, but he can still claim that tax relief. So it's not like an expense, for example. Another thing that can be claimed is the costs of returning home. If the employer does pay for these, and this one does have to be employer paid, it can be tax-free for the individual for a period of up to 5 years as things currently stand. So that individual can fly home. Maybe he's left his family at home, so he can fly home and see them as many times in a year he likes. If the employer pays, tax-free. If the family members come to the UK with him, or even if they stay in their home country, they are allowed to have 2 visits. So the company pays for the family to be together twice a year. It has to be their home. They can't just decide they're going to a different part of the country because they fancy a holiday and isn't that great, company will pay. So it's that kind of planning that needs to be thought about. Social security, again, it's another area where planning can help. It does sit separately from tax, separate rules, separate laws. If somebody's coming to the UK on a secondment, they may be able to remain in their home country system so that they're kept whole, so that they don't have, contributions in one country and then they go and work somewhere else and they have contributions there and then they go and work somewhere else, and it's just a mess. So, like we referred to earlier, if there is an agreement between the UK and home country, an application is made to stay in the home country social security system and out of the UK social security system. This particular rule has a number of advantages, as we've said, but it's an area that employees worry about. It's one of the questions that comes up again and again, particularly if their home social security system is a good one. French employees are very reluctant to come out of their social security system because of the level of support that it offers. And that's fine, they stay in the French system, but for the employer, they need to factor in the additional costs of those contribution levels as an employer. So, I mean, French social security is high, it's around 45–50%, so it's much higher than the UK. That then represents an additional cost to the employer if that person stays in that system. And very often it's used as a negotiating tool. So there's a lot to as with all of this, I think there is a lot to consider, but that's just high level in terms of what can and can't be done from a tax and social security perspective.
Thanks, Louise. Conscious that we are fast running out of time, so we're going to have to keep the answers to the next few questions very headline. There's some specific questions that come in from some of the delegates, so we will get back to you specifically on those questions. So, Rebecca, just like really briefly, I mean, how long does it take generally to apply for a sponsor license and obtain a work visa for an overseas worker? Is this a long drawn out process, or can it be done quite quickly?
So if you have everything that you need, and I must emphasize preparation shouldn't be rushed, you are looking at up to 2 months for that license to be granted, following which then the visa application is normally around 3 to 4 weeks if applying from overseas. And if applying in country, it's up to 2 months. But as I said, if applying in country, they are allowed to stay in the country and their right to work remains. So it should have no bearing on that. If you are considering submitting your license application, it's important to, as I said, not rush the process. The Home Office has no obligation to request documents when considering an application. So if the information is unclear or documents are missing, they tend to refuse as opposed to asking for further information. And I will say with labor coming in, there is an increased scrutiny with license applications, especially for those recently incorporated. Small companies, pre-revenue companies, we're seeing delays in processing, a lot of pre-license compliance checks, and a higher risk of refusal. And with a refusal, there is that possible 6-month ban on reapplying. So it's very important to get it right from the outset. And again, with that UK expansion worker license, specifically for overseas businesses setting up in the UK, there is no option to expedite. So with the skilled worker license, you can expedite to 10 working days for an additional fee. And if you have an employee overseas that you're looking to come to the UK, they can continue to come in and out of the UK while the license is being considered, but not after submitting their visa application. They cannot enter until that visa has been granted.
Super, thanks, Rebecca. And Donal, are there any particular risks from an employment law perspective?
Yes, there are. So we know of cases where employers have issued unconditional offers with definite start dates, and the immigration aspects of the relationship are then delayed, and that presents the employer with an unfortunate legal tightrope to walk, making sure that they comply with immigration law and employment law. There's also then the temptation to offer longer notice periods from the start because the worker's ultimately uprooting to come to the UK. So there's sometimes tension between that conditionality that I mentioned and reassuring the person who's doing that. So to mitigate the risks, I'd say employers should always ensure employment contracts contain conditional clauses stating the start date subject to the approval of the visa or sponsorship license. That does allow some flexibility to move in those situations and avoid that tightrope that I just mentioned. It also provides some clarity around the expectations for both parties and prevents disputes over delay.
Thanks. And Louise, I guess very quickly, I guess we need to also be leaving enough time to get them all set up on payroll as well. That doesn't happen overnight, does it?
Yeah, and I mean that's the big thing that I think people forget. They assume it's instant. If the individual has a requirement for a national insurance number, the individual has to apply for it, and it can take up to 4 weeks. Payroll can't run properly without that number. So I would always build in 4 to 6 weeks for that person to be in as they should be on the payroll and paid.
Thanks, Louise. Right, we have gone 3 minutes over, so apologies for that. Any questions outstanding, we will get back to you individually on those. Thank you very much for everyone attending. Clearly, there's a whole heap of detail in here that needs to be really carefully thought about. So I would suggest anyone seeks advice on any of this from Donal, Louise or Rebecca, rather than trying to go it alone, because it sounds like a bit of a minefield. So thank you all very much. Please do fill out the feedback form. It's super useful, only take a couple of minutes, but it's helpful in us shaping future webinars. Remember, it was recorded, so do share it with anyone else who you think it may be of interest to. So thank you very much. Thanks very much to our panelists, and enjoy the rest of your day. Thank you.
Thank you. Bye-bye.